I love you though. But go into another room. Go in my office. I should go in my office? Please go. I just don't want you to make any noise and then me get mad at you, because I'm going to have to edit this a ton if you do.
Sure.
Okay, appreciate it. Will you break down what happened? With what? Okay. Was that the I love you, go away talk? Yes, it was. Yes, it was. Okay. So the parties in the courtroom were sworn in. The judge states as follows. I'm sorry, the clerk. The clerk swears them in. The court. Good afternoon, everyone. I have announcements to make before I can get appearances, and I'm going to get the appearances of counsel at the table, and then I'll go to the remote. All right, before we get started, no phones, laptops, electronic devices, no Apple Watches or other smartwatches are to be utilized in the courtroom. No picture taking or recording of the proceedings. That's actually been an issue on TikTok recently. I may get into that at some point. If you want to make notes, that's fine, but you must use pen and paper to do that. Do not disrupt the hearing. So this is what was told to the people who were in the courtroom at the time. Yeah, you're not missing any. You haven't missed anything yet. We're just going through preliminaries. Then they make appearances. Mr. Bronstein for Yasha. Yeah, Mr. On behalf of Lynn Spears. Rosengart on behalf of conservatee Britney Spears. Lisa McCurdy for Britney Spears. Mr. David Nelson, former court-appointed co-counsel for Miss Spears. Miss Wiley was listed. Gladstone Jones on behalf of Lynn Spears. Gerald Cohen for Jamie Spears. Park for Jamie Spears. Lorianne Wright for Jody Montgomery. Mary Monda for Jody Montgomery. And then we know, I'm not seeing, Mr. Ingham was appeared as former court-appointed counsel for Britney Spears. We know, Vivian Thoreen on behalf of James Spears. And that's the appearances. Why does Lynn have so many attorneys? I don't know why they would all be in court that day. I don't know. The court, Kevin Cawley was available. That may have been the person who was appearing on behalf of a party, but we don't know who. James Spears was on the phone. Miss Montgomery was present. All right, so I've got everybody checked in, and what I want to do, just to let the council know, please stop. I want to start with Vivian Thoreen, and then I want to go, so this is the court speaking, and then I want to go to Mr. Rosengart, and then we'll see what happens after that. But I want to start with Miss Thoreen first. Miss Thoreen, I know that you have 2 recent filings with the court. One, I'm going to modify some of this a little bit. It's not going to be word for word, just for brevity's sake. I will try my best not to cut off anything that is substantive. Ms. Thoreen, I know that you have 2 recent filings with the court. One is a supplemental stating that Mr. Spears will resign, and the other is a petition to terminate. And of course, those are 2 different positions. So I want to know first, what is your position today? Ms. Thoreen states, yes, Your Honor, thank you. My position today is that the court placed the petition for termination of the conservatorship. I'm going to kill my husband. Is there any way you could be like a little bit less loud? Perfect. We don't have carpet. It's all tile. Everything reverberates. He could be 15 rooms over. I could still hear his voice, and it's still going to grate on me. Anyway. yeah, if Garachi Tams, to the extent that you can while you're here, if you could answer the questions that people have. I'm sorry. Okay, if you guys can't hear them, that's good. It's still gonna grate on me. Okay. Miss Lorraine says, my position today is that the court placed the petition for termination of the conservatorship on today's calendar. This is the issue that should take priority over all other matters. We should be looking at this issue first, and that the termination issue should dictate everything else, Your Honor. The petition is uncontested. Mr. Spears is the one who filed the petition, so obviously he agrees with it. Miss Spears consents. Miss Montgomery consents. Presumably Miss Lynn Spears consents. We're in the process of getting a waiver of notice from the bond company. And so if it pleases the court, and the court can decide to grant the petition today, i.e., you can, without even setting it on calendar, well, she's asking to set it on calendar for today, but just grant the petition to terminate. If it pleases the court can decide to grant the petition today, and notwithstanding that, notice has been provided to all of the relatives to the second degree. And with the termination, Your Honor, that is really going to streamline a lot of the other issues that are on today's calendar. Super important part. It will eliminate and render moot the need to discuss suspension and removal. It will eliminate and moot the issue of whether Miss Montgomery should be appointed as Miss Spears' permanent conservator of the person. It will eliminate and render moot whether or not Mr. Zabel should be appointed as Miss Spears' temporary conservator of the estate. And even according to the petition that Mr. Rosengart filed, whether Mr. Zabel should be appointed as Miss Spears' permanent conservator of the estate. Given that Miss Spears has indicated expressly that she consents to the termination, and indeed, that is the premise upon which we're here, and that's what's driven Miss Spears to file this, then there is no need to discuss any of the permanent petitions to appoint, the petition to appoint permanent conservators over Miss Spears' person or estate. That's actually very confusing, Your Honor. Why would Mr. Rosengart file a petition to appoint permanent conservator of the person and estate when we've got this termination petition that Miss Spears consents to? So I would submit that if the court grants this petition for termination of the conservatorship in its entirety, then that should dictate the schedule and the manner in which the court schedules the balance of the matters. So what she's saying is, Your Honor, everybody here wants to terminate the petition. No one wants to keep this conservatorship. Britney said that on June 23rd. When Rosengart got appointed, he indicated expressly that he would be seeking to terminate the conservatorship. Why are we waiting? Let's just get it done. Now, taking those words for what they are on paper, outside of all other circumstance and context, makes sense. Yeah, why would we? And arguments to the court wherein you say, court, look at how much time and effort this has taken us. We don't want to use your time anymore. Look at how often we're having to come back to here, and the resources that the court's expending and surrounding law enforcement agencies, all of the work and time that goes into all of this, and the commotion, because I promise you there's commotion at the court with regard to this Britney Spears hearing as well. They're having to put in extra time and hours. They just can't speak about it. Your Honor, let's solve all of the problems and we'll just terminate it. Of course, we will then hear what Mr. Rosengart's position is. And consistent with the recent filing that we provided to the court, that the parties should be given an opportunity to try and resolve as many of the outstanding pending issues as possible so that we can come up with an orderly manner in which to end the conservatorship, return the assets to Miss Spears, and try to resolve as many issues as possible without a protracted, contentious, and public fight. I.e., listen, terminate it, which means Jaime Spears would be the last conservator of the estate on record, meaning, remember, the attorney-client privilege sits with the conservator, not with Jaime. So as Jaime sits there, when he is suspended, as he was, the attorney-client relationship between he and Vivian Thoreen or Geraldine Wiley or Cohen or whoever else sits in the attorney position, the attorney-client relationship between those attorneys and Jaime Spears, to the extent he has billed the conservatorship for those communications and the work that those attorneys have done, the communications between them sits with the conservator position, not with Jaime individually. If he paid those attorneys individually on behalf of himself, he could retain that privilege. Because he did not, and because these attorneys were working as attorneys for the conservator of the estate, that privilege sits with the conservator, not with Jaime. So if Jaime gets removed, which is what ended up happening, we know, spoiler alert, the new person, Mr. Zabel, holds that privilege. Super important, because I assume that a lot of the nefarious actions likely were discussed within that, because you talk to your attorney about things that you've done. You talk about what's crossing the line, what's not crossing the line. What have I done that's crossed the line? What's wrong that I've done that I can correct? What can't I correct? What are ways that I can push the bounds of where's the legal line moving forward? Those types of questions are things that you talk to your attorney about. That's what we're here for. So her request here would essentially allow, if the court said, you're right, Vivian, no more time, no more resources, everybody agrees to terminate. We terminate, and he sits as the last person to hold that position, and no one sees those communications. The problem is, this is a very complicated estate. We know that because the 12th accounting that was originally filed last August still has not yet been approved. We know that because there's $2 million in attorney's fees from like one law firm in a 6-month period. So even if the court on that day decided to terminate the conservatorship, we would still have a conservatorship protracted discussion issue wherein Jaime would retain that position over his daughter for some period of time. It couldn't just terminate. And in fact, we saw this too with Bessemer. Bessemer Trust was appointed as co-conservator of the estate in October or November of 2019. The order to actually allow them to sit in that position was not filed until June of 2021, meaning they could take no action. So it takes that much time, though theoretically it shouldn't take that much time. But in this case, especially because of all of the parties and all of the actions and the different aspects to this, it would take some time still if it was terminated on this day that would involve Jaime continuously acting in that role. Okay? That's important because that, I think, lends itself to the reason why the court chose not to terminate it on this day. There's still some actions that Jaime needs to take. Therefore, does he still remain in this position? No, then I can't, it kind of flows through from there. Somebody asked, what are the chances she's running her own Instagram now? I think higher than it used to be. Break. We also request, Your Honor, that in connection with this petition for termination of the conservatorship, we'd ask the court order the parties to a mandatory settlement conference, or in the alternative, to a private mediation, whichever the parties agree to, in furtherance of this termination and in furtherance of the transition to terminating the conservatorship, so that the parties can formally try to resolve these outstanding issues and minimize the expense overall, because it's undisputed that this would be in the best interest of the conservatee. It would conserve judicial resources. That's the, Your Honor, it would take less time from you. And the parties and the court have certainly seen far more complex matters being resolved this way. No, of course, okay? What does mediation mean? what does settlement conference mean? Mandatory settlement conference. Mandatory, self-explanatory. Settlement conference happens in court. So in my county, a settlement conference, and this does not happen throughout, but in my county, a settlement conference is usually had with the trial attorney. So you set your matter for trial or hearing, and a mandatory settlement conference would happen a couple weeks or a month before, and you'd go in with the judge. All the parties would show up with their attorneys, and the judge would attempt to resolve the outstanding issues, settle it, come to an agreement with all parties. The private mediation is the same thing except private. You get a retired judge or arbitrator mediators that work with you. They'll have conference rooms. Everybody kind of goes in their separate. They do them through Zoom now too. Everybody goes in their separate areas, and the mediator tries to push everybody to an agreement on each of the outstanding issues to the extent that they can. Why is this important? In my opinion, it shows a weakness on Jaime's part. Their constant pivoting of different positions from we will not back down, we will not step aside, to we'll step aside when the time's right, to we're going to, we want to just demolish the whole thing, to send us to mediation, shows that they are scrambling. They're doing whatever they can. They're backing slowly off of the cliff until they just fall to their demise. And this situation, knowing that there's outstanding discovery, and Rosengart gets into this in a second, but it's asking the court essentially to say, force us to go to a room to settle, force us into a settlement, force us to not have to have a public hearing. So then it's Mr. Rosengart's turn. Having heard Ms. Thoreen's position, and the court also having reviewed Ms. Spears' petition to remove, as well as her petition for appointment of a temporary conservator, and the court having also reviewed Mr. Spears' filings, the court can proceed in a couple of ways. There's a variety of code sections that I can utilize, but I want to find out what your position is on behalf of your client. Mr. Rosengart says, "Thank you, Your Honor. As an initial matter, we can certainly agree that the conservatorship can and should be wound up and terminated promptly." Side note, winding down is a layman's term, winding up is a legal term if you want to sound smart. Ideally this fall, and that's in our third supplement and our second supplement. The reason we are here today, in our view, with all due respect to Ms. Thoreen, is because on July 26th, as we said we would, we filed a petition to suspend Jaime Spears. Now, just to put things in perspective, because something very odd is going on here on behalf of Mr. Spears. Mr. Spears initially said in his response, "Well, I will go, but I want to negotiate." Then he continued to take that position, effectively seeking delay, seeking a release, and seeking money. I'll go later, delaying. A release, which is, we've talked about this before, I had a feeling, he wants to get his 12th accounting paid, get his fees paid, and then get a release signed off by Britney saying, "I'm not going to go after you anymore." Britney will pay him what she owes him based off of the conservatorship, and he'll get a nice piece of paper saying she waives any and all claims against him. And then, having been forced for the first time to confront discovery, which my firm served for the first time in 13 years, he was confronted with discovery. Discovery, for those who don't remember or haven't been here for prior discussions, is the exchange of information between parties in a litigation period. Mostly in civil litigation. I drafted some today. There are things called interrogatories, which are questions that you provide to the opposing party, like where were you on July 26th could be a question. And there's things called production of documents requests or demand for production of documents, which is, you list out any and all documents with regard to communications you had with Britney Spears on such and such date. That would be served. Things like that. So it's the exchange of information. In California, you get 30 days to respond to that with all of the information. It's very notable. Frogs, Sprogs, RFPD. Yeah, we called it PODs, RFAs, requests for admissions too. We don't know that he served any requests for admissions, but essentially that would say something along the lines of, we request you admit, I, Jaime Spears, fucked up. Admit or deny. That's not a true RFA, but you get what I mean. It's interesting that for the first time in 13 years, discovery was propounded. You have seen over the last few years more momentum on Sam Ingham's part trying to delineate a position by Britney Spears on where this money's going, at least getting some more information on it. But those requests have been informal, meaning an email from Sam Ingham to Vivian Thoreen asking for explanation, not a discovery request, it's important because I can't do a recap because I'm trying to get through this, but I will try to upload this I'm going to upload this to YouTube. I just don't know what time frame I'll be able to upload it to YouTube. The important part about discovery responses is that they are signed under penalty of perjury. So that means that if we go to trial, if we go to a hearing to discuss any of this, discovery responses can be used to prove something. They can be submitted for the truth of the matter. If he says, I did not speak with Lynn Spears on this date, that can be used to prove that he didn't speak with them. Or if he admits that he told Black Box Security to bug Britney Spears' room, that would be used in a hearing to prove malfeasance, mismanagement, criminal actions, whatever. He's signing that under penalty of perjury. So it's very, very important. Sam Ingham, while he got clarification on things, the responses that he got from the attorneys are not signed under penalty of perjury. Theoretically, you could try to use it, I guess, for you couldn't use it for the truth of the matter asserted because it's hearsay, is the bottom line. So in discussing this discovery, important questions to my client, Miss Spears, in terms of abuse, financial mismanagement, and other misconduct. Something remarkable happened that shocked a lot of us, and I think shocked the country. He did a 180 on September 7th and said, never mind, I don't want to be suspended because that would be a very bad thing for me. Let's terminate the entire conservatorship. That should and must happen. I want to emphasize that. My client strongly agrees, and the court knows that. The court heard my client's testimony, I think, loudly and clearly. But why does he want to terminate? He wants to terminate to avoid suspension for a couple of reasons. And this, I think the court knows, but it's important to say out loud and underscore and put on the record. He wants to avoid being deposed under oath. Hello? He wants to avoid responding to extensive discovery. And he wants to avoid, Your Honor, under the Mueller case and the Stein case cited in our papers, something that's crucial here. He wants to avoid his obligation as a fiduciary once he is suspended to turn over his files, not a permanent conservator of the estate, but a temporary, short-term conservator of the estate. And under those two cases, Stein and Mueller, those files must include attorney-client communications. That is what he and his counsel are very concerned about. And when I used to try cases as an assistant U.S. attorney, I used to tell jurors, don't check your common sense at the door, use your common sense. And if we all use our common sense, as with the greatest respect to this court, I know the court will, that explains what's going on here. So absolutely there should and must be termination. But there's a very reasonable, orderly, plan that we respectfully submit the court should follow. And it's very interesting because in Mr. Spears' counsel's first response, what did he say? I quote, he said, "I will resign, but there needs to be a, quote, orderly transition." An orderly transition. Those were his words in his first response. We agree. There should be an orderly transition. And we propose a very logical, reasonable, and organic plan, Judge Penny, and that is his suspension today, followed by a return to court we would submit in 30 to 45 days. In the interim, along with Ms. Montgomery and her counsel, Lorianne Wright, and we work very, very well together and will continue to do so, we will present the court with something that I think the court will want, which is a termination plan consistent with what Ms. Thoreen said should happen in her first response in regard to, quote, an orderly transition. And I'm going to refer the court specifically to page 3, line 22 of their first response, where Mr. Spears' counsel said, even though he must contest the petition for his suspension, and today we're seeking suspension, which the court knows the court can do sua sponte, as opposed to a removal proceeding requiring an evidentiary hearing. The court can sua sponte, sidebar, the court can sua sponte suspend versus a removal which requires an evidentiary hearing. Evidentiary hearing, that we get what that means, right? A hearing based on evidence. Oh, thumpity thumper's back. It's my dog. She thumps. A sua sponte suspension means the court can, on their own, without request by anybody, choose to suspend. Mr. Spears, quote, Mr. Spears intends to work with the court and his daughter's new attorney to prepare for an orderly transition to a new conservator. That wasn't filed months ago. That was filed, Your Honor, as recently as a couple of weeks ago on August 12th. What happened to the orderly transition? My client wants, my client needs, my client deserves an orderly transition. So in short, Your Honor, I think Ms. Thoreen actually said that we were creating confusion. No. To the contrary, there's a very logical process here. Suspension, which I am prepared to address today. My client insists that I address it today, followed by the appointment of a short-term, temporary successor, followed by a termination plan. We'd like it to come back in 30 to 45 days. So that's that November 12th date. And at that point, consistent with the court's discretion, given that everybody agrees and the orderly transition that Mr. Spears' counsel insisted upon as recently as August 12th, the conservatorship should be terminated in its entirety. And with the court's permission, I'd like to address very much, and I'll try to be a little more succinct, and he goes into this. The last thing I will say before I sit down is that something else happened that is very, very dramatic, Your Honor, in the past several days. We learned, I'm sure the court is aware, and it's now in the record, that Mr. Spears and his representatives did something unfathomable. Unfathomable. They eavesdropped on some of the most intimate communications of my client with her children, her boyfriend, and even worse than that, her counsel, Sam Ingham. According to the New York Times, there is specific and credible evidence that they monitored communications with her prior court-appointed counsel. Second, and repeatedly, according to the New York Times, Mr. Spears instructed his security team, which was paid by him, by my client's funds, from my client's estate perversely, and apparently pursuant to the instructions of a business management company as well. My client's former business management company, they plotted and schemed to place a listening device in my client's bedroom. It's shocking, Your Honor. And the reason I bring it up now, and I'd like to address it a little bit more, is it explains the otherwise inexplicable, although we welcome it, but not right now. 180-degree reversal from the orderly transition, quote unquote, that they wanted on August 12th to let's terminate. So what is he saying? He's saying they went from he's not going to step down to he'll step down when the time's right to let's terminate. And the change in that is this bombshell New York Times, thank you, bombshell New York Times piece that went into detail about this eavesdropping of Britney Spears, including the attorney-client communication is so important. It's a fundamental part of the process. And it's interesting that it's such a subject of this hearing, both in regards to the fiduciary position and the and the conservators versus Jaime Spears, right? That part that we talked about earlier. And then here it's extremely important because Britney Spears doesn't have the ability to pass this on. This is an inherent personal attorney-client privilege relationship that she has. It's a warrant. And finally, famous last words. What they really want is delay. They want delay. They want a mediation. They want settlement discussions, which they admittedly, they said that earlier. My client has a right to be heard. As Your Honor said on July 14th, when the court graciously and courteously welcomed me into this court, and I'm grateful for that it's not about anybody else. It's, quote, about her, unquote. Well, I'm here to speak for my client, and she doesn't want a settlement with her father. She doesn't want a mediation with her father, and she doesn't want the delay that his counsel is asking for. Before my time, Mr. Spears went down that road at a mediation. He wants to avoid suspension. He wants money. He wants delay. What my client wants, and we speak all the time, Your Honor, including today, is the following. Suspension today for the many reasons that suspension is mandated, followed by termination in 30 or 45 days pursuant to an orderly transition plan. It's simple, it's logical, it's fair, and it's just. And it's what my client, Britney Spears, who has been abused by this man, not only for the past decade, but since her childhood, wants and deserves. The court says thank you. Miss Thoreen, did you have anything in response? Absolutely, of course she does. I apologize. There was about a minute where I missed Mr. Rosengard's content in the last minute or so I'm not going to be able to respond to that. Gee, that's oddly convenient. Anyway, but I have many thoughts and comments in response to Mr. Rosengard's statements. First, I'll just go backwards for convenience. The party seeking delay is Mr. Rosengard. This logical, orderly plan that he's proposing makes no sense. There's no reason for a suspension when we have termination right now. Why put off for tomorrow what we could do today? We can implement the plan to transition. We can have the 30 or 45 days. We don't need the suspension. It's superfluous. Granting the petition for termination renders that moot. But for some reason, Mr. Rosengard is intent on bringing this issue to the court. And what is really shocking, she says, when Mr. Rosengard talks about this, shocking, that sometimes very dramatic, that something very dramatic has happened in the past several days, this is not evidence. It's just pure rhetoric. Documents that he late filed to the court, first of all, it's not even been verified, meaning it's not been signed by the conservatee. So it's not even clear that his client is aware that he even filed the documents. And we know that he knows the pleadings need to be verified because half of his pleadings in connection with the suspension are verified and the other half aren't. In addition, Your Honor, this so-called evidence, these facts, this fact that he's relying on, well, he just admitted in open court right now that he's quoting statements from a TV show put on by the New York Times. I mean, you guys, it's not even TMZ. Like, do they even have any sources? That's not evidence, and he knows better than that, Your Honor. These allegations, these statements, it's pure rhetoric. This is not admissible evidence. We've looked into this, and we dispute the allegations. And we put that to rest, right? At this time, the video and audio had technical difficulties. Okay, Miss Lorene, I don't know if you can hear me or not. This is the court, but it looks like your screen is frozen, so I'm not sure. We will still have you locked in, whatever. Miss Wiley jumps in. Your Honor, this is me, Miss Wiley speaking. Miss Lorene is doing her best to get back on right now. Then she came back on. I'm on my phone and on video, so if that's a problem, okay. I understand the last thing the court may have heard is we can just put those allegations to rest now. So let me just repeat that for clarity. We have analyzed Mr. Rosengart's allegations in his late filed unverified pleadings, and we dispute them. So they dispute the allegations that Britney's room was bugged. Your Honor, Mr. Rosengart tries to portray Mr. Spears as the one causing delay, seeking delay, and trying to avoid his obligations. One only needs to look at the facts here. The plain language of the statute seeking termination that Mr. Spears filed to see that the plain language of the statute seeking termination that Mr. Spears filed to see that is clearly not the case. There's nothing in there that says Mr. Spears is seeking to avoid a deposition, that he is seeking to avoid his discovery obligation. There's nothing. In fact, the statute plainly states that termination involves a final account and report before the bond can be exonerated. It's right there in the statute. Good attorneys can do this. They can talk around something to such a degree that you're left like, the fuck did you just say? Huh? Anyway, the idea that suspension is part of this logical and coherent plan makes no sense. The idea that a stranger to the court, a stranger to Miss Spears, who is not a licensed professional fiduciary, who just months ago, Miss Spears said she wanted to thank that we had another professional licensed fiduciary subsequently withdraw his name. And now we have Mr. Zabel. Again, clearly, what are his qualifications or experience in even acting as a conservator? But again, if the court grants termination, the issue is moot. Not to mention the fact that Mr. Zabel, as titled in our papers, himself was duped out of $1 million of his own money, and as a CPA had the experience and wherewithal to review a tax return that he had reviewed, and as a CPA had the experience and wherewithal to review a tax return that had he reviewed, should have seen that instead of stating that the value of this fraudulent investment was $1 million, should have said $6.5 million. There are red flags all over the place with the nominee to serve in Mr. Spears' place, Your Honor. There is absolutely no evidence, not a shred of evidence to support suspension, Your Honor. Suspension is an extreme remedy. We're talking about termination. The end is in sight. Your Honor, if you could just tunnel vision, Your Honor, tunnel vision. Just look at the see there's a tiny dot of light up there. There's red all around you, but just focus on that tiny little dot. Just get us to that termination point. There's money everywhere else, but don't look at that stuff. Don't look at that stuff. Just focus your energy, Your Honor. Just the one. You only have the one option. Just one option. We're just going to terminate it on our terms. Terminate it on our terms. Okay. Mr. Spears. I need a drink. I really feel like if I can upload this to YouTube and somebody can pick me up for an audition, I'm just, maybe I have my sights set on Broadway. Maybe I have my sights set on Hollywood. Maybe I have my sights set on a second glass of wine. I don't really know, but I'm just saying maybe this isn't my career path. Mr. Spears has faithfully and loyally served as a court-appointed fiduciary for the past 13 years. His record, it's impeccable. Red flags, we don't know her. Not on our side of the fence, no, sir. Jaime Spears, man, you look up integrity in the dictionary, man. It's a picture of Jaime Spears. That man. Yeah, don't we all think that? And I'm not just talking about the accounting that the court has approved every year. Hey, Your Honor, remember you're on the hook. This is on you too, says Vivian Thoreen. You approved all these accountings. You did it. If he did something wrong, you did something wrong. I'm talking about the regular, ongoing, detailed, and lengthy probate investigators report the court is well aware of. There has never been a recommendation so much as to reevaluate his position. Miss Spears, until Mr. Rosengart entered the case, I wouldn't say that out loud, but whatever, had been continuously represented by court-appointed counsel who is actively involved in the conservatorship proceeding. Mr. Spears has been guided by a team of professionals, medical professionals, financial advisors, legal advisors. Interesting you bring that up, Vivian. We'd love to see that advice that you gave. The idea that Mr. Rosengart tried to infuse his papers, that somehow Mr. Spears came up with a team to imprison his daughter and to unwind the entirety of the conservatorship, Your Honor, that is not only not based on anything in the record, it's belied by the court investigators' reports, the numerous court orders in this case, the reports of the 730 experts appointed by the court. That's a statute. 730 expert. The idea and the question that I think we need to be asking ourselves is why the fuck you're still talking? No, I'm sorry. That's not the question. Mr. Spears has been vocalizing recently Miss Spears has been vocalizing recently that she wants out of the conservatorship. Why didn't Mr. Rosengart file this? Why didn't he file this for his client? And he said he filed a petition that has a successor conservator, permanent conservator of the estate. He tried to backtrack and said, oh, it's just temporary. The end is in sight. Well, if the end is in sight, let's make that the goal. Okay, let's terminate and let's all come back together after all the council's gotten together and put their heads together about a plan. We need to put our heads together about a plan that addresses all of the issues, not just the ones he and Miss Wright decide collectively that they are going to address. Mr. Spears is intimately involved in Miss Spears, his daughter's finances. We know that's the problem. You seem to be saying all of the things that we're saying. You're just trying to say them in a different way. And you need to stop. The idea that there would be a transition temporary for even 30 days makes zero sense. Of course it does. This is a complex conservatorship estate. There are 11 active entities that people who are required to transition would take far longer than just the 30 days that we're even talking about. This is important. Why is this important? There are 11 entities, corporations with records that are not reviewed in their entirety. This is where I have said over and over again, money could be being passed, theoretically, possibly even above board financially, but to people like Jaime Spears. Let's say one of the 11 entities, could you please get her to be quiet? Let's say one of the 11 entities has Jaime Spears sitting on the board and he gets a monthly salary or an annual salary or gets some type of distribution from that. That's where money can no, baby, I got to post this on YouTube. Can you get the dog? Thank you, love. Those are the problems. And now she's Vivian Thoreen, his attorney, is openly discussing it. Okay. And Your Honor, I'll conclude with this. Mr. Rosengart tries to portray Mr. Spears as having done a 180 because he was somehow trying to dodge the suspension. That's not it at all. As they just said, no one was filing a termination for the conservatorship, so Mr. Spears just did it. And as for the basis that the alleged statements that Mr. Spears made conditioning his resignation, I don't know where they're coming from. I have no idea. So, Your Honor, I vehemently object to my client being suspended. I think it's unwarranted, unsubstantiated, unnecessary. It's mooted by the fact that everyone, including Miss Spears, consents to the termination. I.e., listen, let's not put in all this work. There's nothing wrong here. If we don't think our client did anything wrong, that's the entire basis on which they're not, terminating the conservatorship, of course. Mr. Rosengart says, Your Honor, thank you. There were two words that I don't think we heard in Miss Thoreen's response. Best interest. What is in the best interest of Britney Spears? Britney Spears deserves to wake up tomorrow, Your Honor, without her father as her conservator. Can anybody really dispute that? Miss Spears deserves to have her father out of her life as conservator today. Today, Your Honor. Miss Thoreen's plan, and it is a 180, would keep him in her life as conservator indefinitely. That is a disaster for my client. It is against her best interest. It is against her mental health statement of mind. It is against her mental statement of mind. It is against her well-being. For Miss Thoreen to actually say, and I wrote it down, she said, quote, there is not a shred of evidence to support suspension. In her papers, she wrote, there is no adequate reason for suspension. Let's go back to Britney Spears in the best interest of Britney Spears under 2650 sub J. And my firm and I were very careful and thoughtful about what provision under 2650 we were moving under in regard to his suspension. So they specifically picked the subsection of 2650 of the probate code to move under. They brought the petition under this section on the basis of this section provides the foundation for the suspension. We chose J, Your Honor, because it provides this court with broad discretion to suspend him sua sponte today on their own accord. Like they can just do this. We don't have to show that he engaged in gross immorality. We don't have to show that he engaged in faithlessness, although we conclude both down the road. We don't have to show that he engaged in criminal misconduct, and whether he did or not, or others did, will be left up to law enforcement, not us. Hint, hint. But what we took the burden of proving, Your Honor, is that under 2650 sub J and this court's broad discretion, it is time for him to be suspended. So at the end of the day, Your Honor, although what Miss Thoreen, and I don't want it to be personal, what Mr. Spears' counsel is asking for, in effect, is the status quo and delay. She knows the court isn't going to snap the court's fingers and bring down the entire conservatorship today. She wants a mediation. She wants a settlement. But what that necessarily entails is the continuing toxic, untenable presence of Mr. Spears as a conservator in the life of Britney. And Your Honor, she testified so poignantly and so compellingly and so articulately on June 23rd and July 14th about the issue about the abuse that he inflicted upon her, about the cruelty. Miss Thoreen can attack me. I can take it. But she's now attacking my client, her client's daughter. She used the word cruelty. Britney Spears testified under oath on June 23rd and July 14th about Mr. Spears' cruelty, about the toxic nature of his presence in her life. And Miss Thoreen is saying, no problem, it'll all be worked out. It'll all come out in the wash. It'll be terminated. That doesn't work, Your Honor, because what that necessarily means, again, is that according to my client, these are not my words, these are my client's words, that cruel, toxic, abusive man who she also reported was an alcoholic and who she was afraid of remains in her life. Why? What possible rationale can Miss Thoreen give for for asking the court to reject my client's testimony and what my client, because it's all about Britney. It's not about Mr. Rosengart. It's about what Britney, not me, wants. She wants him out of her life today, rather than a lingering, toxic presence. And that's in her testimony, which I'll resist reading to the court because the court obviously internalized it and is well aware of it. So Ms. Loreen may say, well, it was impeccable. Not according to Britney. According to Britney, his service has been abusive. It's been toxic. It's been cruel. And circling back to the law, to sub J, it requires the court, Your Honor, to do exactly what's in my client's best interests. 1 is suspending him today. 2 is setting a date for termination. She's willing to take cheap shots at the temporary successor, a highly regarded CPA, suggesting Mr. Spears was a good conservator. She put this in issue. Now we have to address it. Mr. Spears has zero experience in business. He has zero experience in finance. In fact, he filed for bankruptcy. Mr. Spears presently, today, has a domestic violence restraining order against him. Not in connection with some third party or a stranger, but in connection with Miss Spears' ex-husband and her 2 children. Think for a second, Your Honor, what that does to the well-being and health, emotionally and psychologically, of Britney Spears, the conservator of the person. Her father has a domestic violence restraining order against him. He has no financial or business experience or expertise. He is the one who is running this alone. So I'm not going to get into the CPA who we've nominated. It doesn't merit much discussion other than Mr. Zabel is certainly highly qualified and far more qualified as anyone would be than Mr. Spears. Alexa, dismiss. Sorry to all of you who have Alexas. I'm sorry. What else do we know about Mr. Spears that is very traumatic to my client under the aegis of what's in her best interest today? He has reaped millions of dollars from her estate. Not thousands or hundreds of thousands, millions of dollars. For what? He's not a business manager. He's not a talent manager. Something else is incredibly traumatic to my client, Your Honor, which she raises consistently, and rightly so, is he is taking from her estate more money per month than he has allowed her to have each month. That is something, and the court is aware of this because it's in the record, that is very traumatic to my client. He has been abusive, he has been cruel, he has been toxic, and that's not rhetoric. Those are the words of my client. Those are not my words. The other evidence, and this evidence the court is aware of, and Miss Loreen is aware of, which is why it's so disappointing. It's not even angering. It's disappointing to hear an officer of the court say there's no adequate basis for suspension. There's a mountain of evidence mandating his suspension. Jody has been trying to work with Mr. Spears for years. Jody submitted a sworn declaration. She testified under oath, and it's in our petition. And then he goes through that. Court's also aware of an October 2020 letter in the record from Miss Spears' psychiatrist in which he detailed at length how toxic Mr. Spears' presence was to Miss Spears as a conservator, how necessary his suspension was. So cutting to the chase for a moment, although Mr. Spears' lawyer dresses it up in reasonableness, at the end of the day, she's asking this court, she's asking Your Honor to do something that, with the greatest of respect to the court, doesn't make any sense and is absolutely against my client's wishes and against my client's best interest. That's the standard in 2650 sub J. And that is to let him linger for days, weeks, and potentially months as the conservator. It doesn't make any sense, Your Honor. And the reason I've got into the allegations against Mr. Spears, and we don't need to talk about the New York Times article, that speaks for itself and he'll have to answer for that. But we can even disregard that. It's certainly going to be a distraction for him. And I think Your Honor has the power to ask him, if the court wants, did he place a listening device under my client's bed in my client's bedroom? I haven't heard a denial of it, whether it happened or not, and that will be up to law enforcement. Miss Spears knows about the allegation. Imagine the traumatic effect that has had on her. She sleeps in the same bedroom that her father allegedly bugged. This man does not belong in her life, Your Honor, for another day. The path forward is very, very simple. He must be suspended today. day. Not because a lawyer is arguing for it, but because Britney Spears is pleading for it. She is pleading for it. Sometimes judges are asked to make very hard decisions. This is not such a decision, Your Honor. This is not such a case. This is a very easy decision. I think everybody in the courtroom knows it. I think Miss Loreen knows it. Mr. Spears knows it. He should be suspended today. In terms of some of these side issues, the complexity of the estate, Mr. Spears, as the conservator of the estate, has effectively brought it to a halt. There is no business going on. The estate is being damaged every hour, every day by his presence because, among other things, as Ms. Spears has also testified, she will not work as long as he is conservator. He's brought it to a grinding halt. With respect to Ms. Loreen, this is not rocket science. A business manager will work with Mr. Zabel, the CPA who's represented by a well-respected member of this bar, Justin Gold, during a transition. What should happen here, Your Honor, is quite simple. He should be suspended today. The temporary conservator should be appointed, which should come back in 30 or 45 days. We will expect the court to sign off on that plan. The same type of orderly transition Ms. Loreen wanted on August 12th, and the conservatorship should be terminated that day. What will happen is if the court does not proceed down that very logical, fair, thoughtful course, is he remains in her life for days, weeks, and potentially months. My client will be extraordinarily distraught if that happens, and I'll say to Ms. Loreen, my client will be extraordinarily distraught if Mr. Spears remains conservator for one day, one more day. Having heard that, why would she ask that he remain for one more day? If he cares about his daughter, if he loves his daughter, if he cares about the law, which says the court should do what's in my client's best interest, he will resign today. Your Honor, this has been going on for far too long. In November of 2020, Mr. Ingham made an argument for suspension. The court remembers that. Mr. Ingham pointed out that under Section 2654, the court had the power to order suspension sua sponte. I wasn't here, Your Honor. This was before my time. From reading the transcript, it appeared the court was thinking about it, but there were logistical issues, procedural. There aren't any of those issues now. We did it thoughtfully. We did it quickly. We did it properly. The July 26th petition requesting the suspension verified. So, Your Honor, Ms. Loreen's a good lawyer. She's good at creating confusion. But for her to argue there's not a shred of evidence mandating his suspension today, for her to argue, quote, there's no adequate basis for his suspension today, I'm not going to make it about Ms. Loreen, but it certainly does go to the credibility of Mr. Spears. So finally, again, I'll say it for everybody on screen to hear. Britney Spears, Mr. Spears' daughter, wants him to be suspended or resign today. She will be incredibly distraught if she learns that he remains as conservator for another day, which at the end of the day is what they're asking for. Please hear the plea of my client, Your Honor. I'm here on her behalf. I'm her voice today. She has asked for Mr. Zabel, the CPA, to work with Michael Kane, the business manager, and other people for the next 30 to 45 days after Mr. Spears is suspended today. And then we will have a termination. Court asked a question, and I want to hear one more time from Ms. Loreen, and then I'm going to let you know what my thoughts are. Under Probate Code Section 2654, I note that wasn't raised in your papers. But that is a statute that is specifically focused in on suspension. You can utilize that section. So I wasn't sure why you were why you were focusing on 2650 sub J. Rosengart says, we're focused on that because that's what's in the best interest of the conservatee. I was referencing 2654 in passing. I agree that this, Rosengart says, so the court's saying, why are you using 2650 sub J and not 2654? Rosengart says, you have many tools in your arsenal to mandate suspension. I'm not discounting 2654. Ms. Loreen says, Ms. Loreen, do you have a final comment to make? She agrees with Mr. Rosengart. This is not rocket science. It's not rocket science. What Mr. Rosengart has been saying over and over again is that he is seeking to delay the termination. Oddly enough, and I don't know where in the probate code it says this, but somehow his understanding of the statute is that if the court grants Mr. Spears' petition to terminate the conservatorship, that somehow Mr. Spears is going to be the conservator of the estate indefinitely, that makes no sense. If the court grants termination, the conservatorship's over. We're talking about wrapping things up and transferring assets back into Miss Spears' name, or however she wishes to have them passed in title. That's a separate and distinct but related issue as to termination, Your Honor, because as the statute says, we've got to wrap this up. We've got to have the final account and report, and Mr. Spears fully intends to comply with his obligations. This court's well aware that Mr. Spears has served faithfully and complied with every single obligation that he's had and reported to the court. Has worked his hand in hand with the CAC attorney, the court-appointed counsel Sam Ingham, before he resigned. So yet he has that somehow Mr. Spears is going to be her conservator. That's a semantic. It's an argument. But let's also be clear. I think that Mr. Rosengart's argument is that somehow the suspension is going to get rid of Mr. Spears and excise him from Miss Spears' life. Let's not forget that Mr. Spears is her father. And when Mr. Rosengart talks about a stranger, an unlicensed fiduciary, who the court has no idea who he is, and someone who, and Mr. Rosengart stops, Your Honor, it's who Miss Spears wants, it's who Britney Spears wants. Miss Lorena speaking, okay? When we talk about who has been there for Miss Spears, the world remembers how the conservatorship came about, Your Honor. Here we go. I'm not gonna lose my cool. There were two very, very public 5150 holds that were going on when the conservatorship came about. That's not confidential. The world knows about that. But I want to move on. Yeah, I've got a little bit more left. Just go ahead and eat. Just go eat. Just leave mine. Okay, awesome. Mr. Rosengart spent considerable time talking about what is in Miss Spears' best interests, and he made all kinds of allegations about abuse, toxic nature, etc. And he referenced Miss Spears' prior testimony. Well, that may be true that she testified to that, but she wasn't cross-examined. Nobody knows the veracity of those statements. Even Miss Wright, counsel for Miss Montgomery, stated that she disagreed with Miss Spears' testimony, that there were some misstatements in Miss Spears' testimony. Termination, that statement is saying Britney lied. No one questioned the veracity, truthfulness of the statements. She wasn't cross-examined. AKA, Britney wasn't telling the truth. Termination is the most obvious, expeditious route. The cheap shots that I supposedly made to this stranger to the court who's going to take over a $60 million estate, and the allegations and the facts that Mr. Rosengart made about Mr. Spears, well, let's take a look at what the actual facts are with regard to Mr. Spears. He was appointed as the temporary conservator in 2008 with a co-conservator of the estate, Andrew Wallet, who the court is well aware is a highly respected trust and estates attorney and a conservator and fiduciary in many different capacities and over many different trusts, estates, conservatorships. Oh my Lord, all the conservatorships. Feel like that may be a red flag. Together, Mr. Spears and Mr. Wallet served faithfully, loyally, benefiting her estate. There were specific and detailed orders regarding how the investments were to be made, how the money was to be managed. And it was Mr. Wallet who was delegated that authority. So the idea somehow, again, that Mr. Spears is unfit to serve, well, that completely flies in the face of the past 13 years where Mr. Spears was appointed. Miss Spears consented to his appointment. The conservatorship was made permanent. Remember, they think that this was a voluntary conservatorship. And year after year after year, the court kept Mr. Spears as a fiduciary for Mr. Spears' daughter. The idea that Miss Montgomery's declaration, where she's attesting to things over which she has no personal knowledge, She's not a doctor. She's not a therapist. She's not a licensed, well, she's licensed, a fiduciary. I'll give her that. But the idea that somehow she's an expert, she's not an expert in those medical decisions, Your Honor. We've objected to the declaration as lacking foundation and as calling for hearsay. And the idea that she believes it's her strong recommendation that the conservatorship not be a family member, well, again, we only look at the record. For the past 13 years, Mr. Spears has served both as the conservator for Miss Spears' person until relatively recently, and continuously as the conservator of her estate. With Mr. Wallet until 13, and then with the sole blessing, and then sole with the blessing, with the cooperation and the guidance of her CAC counsel before he stepped down. So the idea that the court would contemplate suspension in light of what Mr. Rosengart just said, he conceded, he disavowed the New York Times, the evidence, the so-called evidence that he cited from a TV show. So that's where he's getting the surveillance allegation that has no place here, Your Honor. And to the extent if the court's seriously considering suspending Mr. Spears based on these papers, verified or not, declarations or not, there's a lot of medical facts, medical information that Mr. Rosengart alluded to in his argument, and I would reserve the right to ask that the court seal this courtroom so that I can defend my client further to support against suspension and support termination instead. That is an obvious. That is what Miss Spears wants. She said no fewer when she testified than 7 times that she wanted the conservatorship to be terminated. And when she was railing against what was going on, the complaints that she had, they weren't about Mr. Spears. They were about her medical issues. They were about Miss Montgomery. I won't repeat what she said, but there were instances where that were very specific, where Miss Spears had a lot of concern and objection about the way in which her medical care was being run. And you know what, Your Honor? The petition to appoint Miss Montgomery is on calendar today. I don't know why Mr. Rosengart hasn't withdrawn that petition, because in that petition, Miss Montgomery would be taking over Miss Spears' ability to make medical decisions for herself. There is an allegation that the court previously made in order taking away Miss Spears' ability to make medical decisions. That never happened. So why are we talking about the permanent conservatorship? Yada, yada, yada. And then Mr. Rosengart speaks again. I don't want to go in circles, and I won't, because there wasn't a lot that we've heard that was new from Miss Lorene. What we still haven't heard in her address is what is in the best interest of my client. And I refer Miss Lorene to the conservatorship of Navarrete, which I know the court is well aware. It must be a seminal case. It's cited in our papers. The court is aware of it through the court's distinguished tenure on the bench and before. A conservatee cannot be forced against her wishes to have a relationship with her father. Miss Lorene, once again, and I don't know if this is just advocacy or if she's intentionally trying to deceive the court, that's a big allegation, suggested that these were my allegations. This isn't about me, it's about Britney. Britney is the one who testified. Britney has testified that he was toxic. Now Miss Lorene may not want to believe that, so maybe let me suggest this. It doesn't matter if Miss Lorene or Mr. Spears believes that. It's actually irrelevant, because Miss Spears, Britney Spears, believes it. She's telling the truth. But even if she weren't, even if the court were to accept what Miss Lorene just said, that Mr. Spears deserves the gold medal Father of the Year, which is sort of laughable, Your Honor, that he said that in court, which is laughable. That wouldn't matter, because my client believes that he was abusive, cruel, and toxic. And she's right, and that's what matters. Just a couple of other points. I think a lot of us are scratching our heads. Why is she doing these gyrations to avoid suspension? What's the big deal? What are they afraid of? His daughter wants him gone. Step down. What he's afraid of is the revelation of his corruption. Because under the Mueller case and under the Stein case, they're required to turn over their files. And if the court doesn't grant suspension, that will not occur. And I believe in those files, we will find evidence of his corruption. And worse, so Miss Lorene wants to suppress evidence of his corruption. It's not our main point, but it's relevant because it explains why she's twisting and turning to avoid the obvious, which is his suspension. And my last point, Miss Lorene said I was about, and then finally, Your Honor, my last point, Miss Lorene said I was about disavowing the New York Times. This isn't about the New York Times. This is about a whistleblower named Alex Vaslov, who very credibly provided specific and credible evidence about what Mr. Spears did here in terms of the bugging and eavesdropping of his daughter. But again, we don't even need to deal with that. We have it. We could throw that out. Well, we have it, but we could throw that out. All we need is testimony of Britney Spears. All we need is the fact that Mr. Spears, sitting here today, has a domestic violence restraining order against him involving Ms. Spears' children. I came into this case, and I'll be forever grateful to the court as a commercial litigator, not as a conservatorship lawyer, but I'd ask the court, that's interesting. I'd ask Ms. Lorene, I'd ask the counsel on screen, is there a precedent for conservatorship to be in place who has a domestic violence restraining order against him, let alone requiring him to stay away from the father of the conservatee's children? So he's saying, I don't practice probate law regularly. I'm a litigator. That's an in-court arguer. And he's top notch. So he doesn't know probate law like the back of his hand. But is there precedent for allowing a person to serve as conservator when they have a domestic violence restraining order against them related to these specific parties? Like, is that normal? Although there's about 15 other pieces of substantial credible evidence warranting his removal. And then finally, just going back to Miss Montgomery, Miss Lorene is wrong on the law. She's wrong on the facts and she's wrong on the law. This is not a jury trial. The rules of evidence don't strictly apply. You have a very sophisticated jurist, Your Honor. Hey, Your Honor, I think you're really awesome. You're really sophisticated. Just suck up. And the rules of evidence don't even apply in bench trials, let alone would they apply during oral argument. And under the case of Tailing versus Superior Court, the court held the admission of hearsay was proper in a hearing. The hearsay rule, like other technical rules of evidence, is generally not vigorously enforced in bench trials, so the judge may receive all relevant evidence. Everything we've heard today is relevant. And finally, Miss Montgomery is an expert. He goes on, if this court wants to disregard Miss Montgomery's sworn testimony that Mr. Spears is toxic and must go, I suppose the court can do that, but still wouldn't matter because it'll come back to one person and one person alone, Britney. I mean, there is a through line in his argument. It's an easy call, Your Honor. I hope and pray that the court appreciates my passion. I feel strongly about it because my client feels strongly about it. Just logistically, after he's suspended today, Mr. Gold, Justin Gold, known to this court, will be working with the CPA and the business manager. Mr. Spears will still have a fiduciary obligation as a suspended conservator to work with the new team, which will require Mr. Kane, the business manager, who Mr. Spears chose for the orderly transition. So it's simple, Your Honor. In terms of the path forward, my client is begging this court to do the right thing. Suspend Mr. Spears, pursuant to her wishes. Appoint the temporary conservator. Let's come back. Responsible termination plan. Miss Lorene asked for another chance to talk. So I'm just going to let both of you know. I'm going to let Miss Lorene say something, but then I'm going to be making some rulings. Your Honor, so this is Miss Lorene. I did not use the word what is in Miss Spears' best interest, so let me clarify that it does not appear as though I skirted the issue. Everything Mr. Spears done has been in her best interest. It is only in her best interest that he had in mind connection with his service as conservator. What is in Miss Spears' best interest? Would it be in her best interest after begging and pleading with the court no fewer than 7 times for termination of the conservatorship to wake up tomorrow and she's still in a conservatorship? Or will she wake up and if the petition for termination is granted, she will both not be under a conservatorship and 2, her father will not be conservator by virtue of the termination? Not true. What is not in Miss Spears' best interest, Your Honor, is to bring on a stranger with the added expense. So she's saying, the argument is, I saw somebody saying, what does it mean? The argument is, what is in her best interest is the conservator must be suspended if his service in his position is not in the conservatee's best interest. Vivian is taking that logic and saying, well, what's in her best interest? Terminating the conservatorship or letting it stay in place? Rosengard isn't asking for termination. He's just asking for suspension. And Britney has again and again pleaded. You're saying she wants her father gone, but I'm saying Vivian saying this. I'm saying she wants this conservatorship terminated. So we are talking about her best interest, but we're talking about her best interest in regard to the conservatorship in whole. It's not Hocus Pocus, it's a Hogwarts. There's no forced, let's see. Navarrete doesn't even apply. That was a case, Your Honor. Judge Pierman in Riverside County recently, he, over the conservatee's objection, forced her to visit her father. She appealed that order. There's no forced visitation order in place, Your Honor. Mr. Spears hasn't talked to his daughter in many months. He would love to. He misses her dearly. Navarrete doesn't even apply. There's no forced visitation. This was a developmentally disabled conservatee with a contested conservatorship and without the appointment of it. So that she's distinguishing Navarrete. What is really troubling about Mr. Rosengard's most recent statement that really drove the point home is the delay, the purpose of the delay and the purpose of not terminating today, which is the final reason, because we can kill two birds with one stone here, is that he's now implicating that he wants the files of Mr. Spears because he wants to go digging. He wants to unwind all of these orders. At the beginning, when I made my argument about these papers that were filed on Miss Spears' behalf, where he's trying to undermine the integrity of the judicial system, the court officers, the probate investigators, all of the fiduciaries and counsels and teams that have been involved, he's trying to dig something up. He wants the files. That's the reason for the delay. It's not Miss Spears' best interest. Her best interest would be served by waking up tomorrow and no longer being in conservatorship. Court. So she's right in that that's why he's not requesting termination. But I would argue that's also wrong. Yeah, she wants her money back. That's the problem. There's an outstanding interest. Well, I want to thank both of you. This is the court, and I've been reading all the pleadings as they've been coming in, the supplements, the various declarations. I know that both of you, from your own client's perspective, are giving the court, your best arguments in this case. But as I've said, I've read and considered the pleadings, and I've heard from every one of the parties today. And I think that, based on what I've read in the file, the pleadings that have been filed concerning both the termination and removal, the petition for appointment of a temporary conservator, I've looked at everything. But I do believe that under Probate Code Section 2654, I believe that the suspension of Mr. James Spears as conservator of the estate of Britney Spears is in the best interest of the conservatee. The pleadings filed by both parties, in my view, make it clear that the current situation is not tenable, and only a change in the present arrangement makes sense at this point in the pleading. The pleadings appear to the court to reflect a toxic environment, which requires suspension of James Spears as conservator of the estate of Britney, effective today. This change, the court finds, is in the best interest of the conservatee. This order, take a break. Let's see. So then Mr. Zabel was appointed. I want to see if there's anything. She goes through his powers. Order a bond of $47 million. Then sets the hearings. Miss Lorraine, how soon can you get all of that information to Mr. Gold's office? Mr. Gold, Your Honor, very briefly, the court did make the order to turn over books and records. Given the short transition period we're looking at, can we have a date certain by which the books and records will be turned over electronically? Maybe within 5 days or a week so that we can keep it tight. Yes, how soon? We'll figure out in due course. It's a complicated question. Figuring out what specifically he needs. So Mr. Rain says, I'm looking at Probate Code Section 2250.6, the title of that. She says, this point gives me some pause. If Mr. Zabel were a licensed professional fiduciary, but he's a stranger, we don't even have his CV, we don't know what prior experience he has, and to have a multi-million-dollar estate turned over to him, even on a temporary basis, given his history, I appreciate the court is not accepting the request for judicial notice, but there are facts in the opinion that I think warrant some further investigation beyond just a simple background check. They were asking to take judicial notice of the court case in which he was involved for that $1 million. And she said, we don't take judicial notice of that kind of stuff. I think Rosengart says, I think it was disrespectful to the court for Miss Lorene to make that statement. He's a nationally recognized CPA. I can't imagine there would be any issues given what we heard this morning. To set the termination for 45 days out. And before we take one break, I'd like to request a statement of decision in connection with Mr. Spears' suspension and the appointment of a temporary conservator. I want to say before I forgot, Your Honor, and then that's what the court says. Under the section that I utilized, it's not an appealable order. So that's why she wanted that. So that's that on that. Then a recess was taken, and then there were additional matters that were handled. Let me see. There's about another 25 pages of transcript left. So at this point, it's 6:30 in my day. I'm gonna go. The next hearing date is November 12th. So my voice is going anyway. So I'm thinking. Oh shoot. I'm trying to think in my head. I can try to come back on Wednesday to go through the balance of this, and I'll try to make some videos tomorrow about what we talked. Yeah, Jamie's out. Jamie's been out since the 29th of September. I just wanted to review the transcript with you guys and show you the arguments because we only saw them piecemeal on Twitter in real time. We haven't seen the transcript until today. Don't worry if you missed it. It's going to be on YouTube later, probably tomorrow. I have to download it, and TikTok hasn't been great about that lately. So I will make a couple of videos dissecting this tomorrow, but that's it for the night. If you do have any questions, do we know if he's had any of his depositions? I don't think so yet. If you do have any questions, watch out for the videos tomorrow and post them there, and then I'll try to answer them tomorrow. But yeah, that's it. I hope you guys have a great night. Oh. Enjoy your day, Wednesday, Tams. You deserve it. I'm sorry. It's going to be a good one, though. It's going to be a good one. Celebrate the love anyway, because it was love. It is love. Love to you all. Talk soon.